all five of you here late, relatively late on this Thursday afternoon. I realize some of you might have to leave early, but thanks for being here, at least to begin. Give you a little bit of background on this bill. This bill is kind of I guess I'd say a response to or a follow-up on Senate Bill 2, or Act 2, which passed earlier this session. Kind of rehash a little bit of the reasons for this bill and why this bill is here today. That bill dealt with the contributory liability theory with regard to products liability. It came out of a variety of cases, but I think the most notorious case, you want to call it that way, was a case in which lead paint is a concern in a case in which lead paint manufacturers may be sued by people who claim that lead paint in a house resulted in elevated lead levels in children, which may have a negative effect on the health consequences. In a case, the court ruled that you did not have to show which paint company, in essence, had paint in that house. And so you understand most of these cases involve houses that were built before 1930. So they go back and they claim that any one of several paint companies could have been the paint company whose paint was used in a house at that time. And as the result, a variety of paint companies or a variety of companies who made ingredients in that paint may be sued. It became apparent subsequent to time of that bill being signed that many court cases were filed at the last minute to try to take advantage of companies that were producing paint maybe at the turn of the last century. There are a variety of public policy problems here. No one is disputing the fact, though that is questionable as well, that today that companies should perhaps be held liable if they produce paint which is used in these houses. However, there was a concern that when these decisions, primarily known as the Thomas decision, came out, that it retroactively dramatically changed where these paint companies stood. I mean, after all, I don't care what type of product you are producing. I think when a manufacturer produces a product, they have to be aware that maybe someday they're going to be sued for liability. We have here a situation in which their exposure was retroactively greatly increased because of a court decision which came up with this contributory liability thing in which they said any individual company can be liable not only for the product they produce, but any other company that produces a similar product. And this retroactive change to the law is just quite frankly a very scary court decision. And who can go into business, I don't care what you're producing, if 80 years later a court can say you're not only for doing something wrong yourself, but you're on the hook for anybody else who's producing the same product. You're on the hook for them as well. So the purpose of this bill is to say that the effects, particularly with regard to contributory negligence, that went into effect for Act 2, apply to all cases regardless of when they were filed. And in particular, I think some of the people in your testimony today who might not like this bill are here because they want that Thomas decision to apply to cases which were filed immediately before this bill became effective. And it seems to me that when a court does something as outrageous as was done as Thomas, when they retroactively tell businesses that were producing paint in 1900 or 1910 that not only could you be liable for damages, if there were damages, and that's questionable, for pigment or for ingredients in paint, but you have to be liable for paint produced by any paint company in the United States in 1900. And that obviously, you cannot operate commerce with that type of decision made. Again, this decision will not result in these cases not moving forward, but it does mean these cases have to move forward under what we thought the law was 25 years ago, which means they have to find out which company is producing this paint.
Thank you for your. Oh, I'm sorry. Were you?
No.
Okay. Thank you for your comments here and for bringing the issue to light. I guess just a couple of quick questions and comments from myself. So, this legislation is largely stemming from the Thomas decision. And it's my understanding, and I want to confirm that it's your understanding as well, that at the time of the Thomas decision, and actually probably hereafter, there was no other court anywhere in the country that had issued a ruling similar to Thomas or identical.
That's a very good case. That's a very good point, right? I think it is such a bizarre interpretation of the law, saying that your company can be on the hook not only for what you produce, but for any other company that produces a similar product. But there was no court in the whole country, court in the state of Wisconsin, who came up with it. So ridiculous. I mean,
the question that I have had, as others have started to discuss the bill, some have said, I thought we addressed this in Act 2. And I think your testimony kind of speaks to what we have addressed and what we have not addressed in Act 2. So Act 2, in essence, applied to any claims made after enactment of Act 2. Your legislation would look back to those cases filed before the enactment of Act 2. Is that
right,
correct?
exactly. I'm not sure the exact effective date. It was something like March 15th of last year, sometime around then. And there were many cases filed in the month before enactment or 2 months before enactment. And we are saying that this will apply to those cases as well.
Okay. And then in making that move to look back, have raised some, I guess, legal questions. I think Senator Erpenbach received a memo that I received, an identical memo too, I think it was identical, memo too, from legislative counsel regarding the constitutionality of this proposal. Could you speak to either that memo or your thoughts on the constitutionality, because those questions haven't been raised?
Right. I think I'm going to distinguish between substantive changes of the law and what I'll call procedural remedies. These people still have the ability to sue manufacturers this paint. We can discuss whether there's any merits of those cases separately. That this bill doesn't deal with it, and I would say that, quite frankly, it's scandalous. The lawyers are leading people to believe that the lead paint in these houses is responsible for the increases in the levels in their children's blood. But under this bill, we are not retroactively changing their ability to sue the company that produced that paint or the amount of claim that they may have against the company. We are changing a procedural thing whereby they are able to sue all these other companies. And I think if you look in case law over a period of time, things are distinguished there. I'll give you an example of something that was retroactive and a court said was wrong. Early on, when I was in the legislature, I guess I've been here so long, I was the only one. I was the only one here of these five who was here when this.
Oh, no.
Whoa, come on. What am I thinking? Right here.
Before you were.
That's right. I'm looking at everybody. Miss etc. Okay. Have it. Blending into the paint. There was a bill in which we restricted the amount of non-compensatory damages related to medical claims. And in that bill, we reduced the amount of money a plaintiff could receive if they sued a doctor for malpractice. That bill, insofar as we tried to make it retroactive or apply to cases that I was going to call in the pipeline at the time, was struck down. And the reason it was struck down is we were telling those plaintiffs, what? You thought you had a claim of $1 million. We are not going to let you knock that. You were right to $1 million. We're not going to knock that right down to whatever we try to do in that bill, $250,000. Okay, because we're taking something away. In this bill, we are not taking away the rights of the plaintiffs to sue for the amount of damages they can get. We are still in this bill saying if you feel your child or your child is damaged $100,000, you can still get the $100,000. And if you feel ABC Paint Company it caused your child $100,000 damage, you can still sue ABC Paint Company for $100,000. What we're doing here is we're changing a procedural thing whereby you can no longer say, we're going to go after, whatever, 30 paint companies or something like that, and say you're all on the hook. So in that regard, I don't consider this a retroactive piece of legislation at all. Now, it is something that we're dealing with procedurally because of, I think, an unethical decision in which retroactively you are telling companies that have been in business forever that you are on the hook, not only if you produce paint, but if any of your competitors produce paint as well. And that's a big distinction.
Thank you, Senator. Questions from committee members? Senator Urban.
Okay, apparently the alleged council member was talking about what you're talking about. Doesn't flat out say it's unconstitutional, but it raises significant constitutional concern.
I would be surprised if somebody doesn't file a court case, but based upon what I see, I think they're gonna lose their case.
Okay, and there's also something introduced into the bill draft that it's a response to the legislative council memo. Do you know who submitted this?
I'm sorry, I
The name was cut off. No, the name was, it's part of the bill draft. The name of